Ready? Exercise number 24, legal matter. Start. In our opinion, in view of the language of Order 41, Rule 3A of CPC, it is difficult to hold that it gives any additional right to claim condonation under this provision. A division bench of the Madras High Court had the occasion to consider this question in the case of Managing Director Thanthal Perrier Transport Corporation Villipuram versus KC Karthiaini AIR 1995 Madras 102, wherein it has been held as follows. Quote, next para. Counsel for one of the petitioners also contends that Order 41 Rule 3A under bracket 1 gives a further right to claim condonation of the delay. In addition to such right under Section 5 of the Limitation Act, and that Order 41 Rule 3A will have application only if the said Section 5 is invoked. According to him, these petitions to condone delay are filed under Section 173 of the Motor Vehicles Act and not under Section 5 of the Limitation Act. In this connection, he relied on Nirmala Chaudhary versus Bisheshwar Lal AIR 1979, Delhi 26, and State of Assam versus Govinda Chandra Paul AIR 1991, Gujarat 104. The observation in AIR 1979 Delhi 26 is no doubt as follows. Quote, next para. The newly added provision of Rule 3 of Order 41 in the Civil PC gives an additional right to a litigant to claim condonation at the time of presenting the appeal. In State of Assam versus Govinda Chandra Paul AIR 1991, Gujarat 104, also similar view appears to have been expressed in the following words. Besides, this rule is not in derogation of Section 5 of the Limitation Act. In fact, it is in addition to that. Stop, next para. But we are unable to subscribe to this view, since Order 41 Rule 3A CPC has only been inserted by the Amending Act 1976 in order to prescribe the procedure for securing the final determination of the question as to limitation. Even at the stage of admission of the appeal, the rule does not prescribe the period of limitation for an appeal. The period of limitation is provided only under Article 116 of the Limitation Act 1963. In respect of appeals, and it cannot be said that Order 41 Rule 3A gives any additional right to litigants to claim condonation. Moreover, condonation of delay is not a matter of right. The litigant who comes to court after the prescribed period of limitation is bound to satisfy the court that he has sufficient cause for the delay. We respectfully agree with the aforesaid observation. To put the record straight, it is relevant here to state that it has also been contended on behalf of the appellants that principles of natural justice demand that in case of the appellants showing sufficient cause, the appeal deserves to be heard, though presented beyond the period of limitation. We are of the opinion that appeal has to be presented according to the procedure prescribed. The remedy of appeal is a statutory right, and hence it has to be presented in accordance with the procedure. the manner and within the time prescribed by the statute, and the principles of natural justice are not remotely attracted so far as the question of limitation is concerned. Having held that the delay in filing the appeals cannot be condoned, we have no option that to dismiss all the appeals as barred by limitation, and they are dismissed accordingly. Full stop. Thank you.